Let's have a look. Issues to consider. Is there a statutory bar onshore? The statutory bar might be section 46A, which is a bar for unauthorised maritime arrivals. People arrive on a boat of a certain period. Section 48 is a bar, but not an absolute bar. There are exceptions to section 48. There might be public interest criteria, PIC 4020, which is a 3-year ban. That's a refusal ground. So it's PIC 4020 is we refuse you if you provided false information in part of the application or fraudulent documents. Then that creates, in turn, if that's refused, a 3-year bar from applying for other visas, except in certain circumstances. Special return criteria, this is for people who are offshore. The PIC 4020 might affect someone offshore as well. Section 48 doesn't affect anyone who's offshore. So, what is special return criteria? 5001 and 5002. 5001 deals with people who are deported or have had their visa cancelled or refused under character reasons. No one is deported anymore. Now, this may come as a shock to you because you're probably thinking, hey, I've seen people deported on the news. They talk about deportations, blah, 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 blah. They're wrong. They're not deported. No one is deported anymore. It hasn't happened since the late 1990s. Now, this is not just me being tricky and pedantic on the words. Deportation under Section 200 has specific requirements, and it does require a criminal conviction, and there's a time period in which that conviction has occurred, and it has to be at least a 12-month sentence in jail. But because it has other complications in terms of what needs to be done, it's much easier to remove someone, literally just taking them from the detention centre and putting them on the plane, than having a deportation order issued. So that removal power under Section 198 is much easier to do for the government than the deportation power under Section 200. Now, deportation, as Michelle knows, is one of my trigger words. So don't talk about deportation because you'll just get me upset. It's removal. Nobody's deported, they're removed. Okay. Does the applicant have the sponsor have restrictions? Remember, we looked at some of those restrictions last week for the sponsor, REG 120J, multiple sponsorships, 120KB, 120KC in terms of relevant or registrable offences, both defined within the regulations. Is there a substantive visa onshore? Now, substantive visa is a visa which is like a visitor visa. It's basically any visa that's not a bridging visa. Bridging visas are not substantive visas. Bridging visas are there to keep you lawfully in Australia whilst the process is ongoing. They don't give you permanent status. There's only a temporary status. Whereas other visas might be a temporary visa, might be a permanent visa. They're known as substantive visas. If you've had a visa, if you have made an application for a particular visa and that is an ongoing application, whilst you've arrived in Australia, let's assume you arrived on, say, a student visa or a visitor visa and there was no barrier to your lodging, then you lodge your partner visa on shore, then eventually you get a bridging visa A because you lodged on a substantive visa. If, however, you're rolling through on that bridging visa A and you wanted to lodge some other visa application, now you have an issue, what's known as Schedule 3 provisions, because you're no longer holding a substantive visa, you're holding the bridging visa A because your substantive visa has ceased. So that's when your Schedule 3 provisions can come up. Commonly, I see this in partner visa areas. People are on, say, they apply for a student visa and it's refused. They're off in the tribunal trying to get that fixed. And they get married or de facto or have a child or something in Australia and they want to get the partner visa going. All of a sudden, they have a Schedule 3 issue because we'll see how that works. And that's a potential refusal ground, not a bar, but a refusal ground. Health issues for visa applicants. There's a waiver in the health provisions. PIC 4007 is the waiver. We're not going to go into that in a great lot of detail tonight. In fact, hardly any at all, just identifying it. And public interest criteria are all the Schedule 4 provisions. 4007 has the health waiver. 4005 says you've got to do the health, but there's no waiver available. So some visas don't have a health waiver, such as the contributory parent visas, whereas the partner visas do have the health waiver, so they have 4007. So we'll see this when we have a look at what the visa subclass says and what numbers appear in the 400 series on that. Character issues for sponsor and the visa applicant. Are we dealing with marriage or de facto? These are all the things we might be considering when someone walks in and says, hey, I want to lodge a partner visa. Unauthorised maritime arrivals. These are people who have come to Australia by boat within a certain period of time. They can't apply for anything unless the minister literally lets them do so. It's a ministerial intervention power. Section 48 is a refusal ground where it says if you've been refused a visa since last entering Australia and you're in Australia and you don't have a substantive visa, so that means you might be on a bridging visa or maybe you're unlawful, then in those circumstances, can you apply for a partner visa? Well, you can if you meet the criteria for the partner visa and the exception that is allowed in Regulation 2.12. And Reg 2.12 and Section 48 link together. Just try to somehow glue those two series of numbers together in your head. Section 48, Reg 2.12. Because 2.12 are the exceptions to not being able to lodge an application. And two of the exceptions are partner visas. But there's always a but. Remember, there's always a cloud around the silver lining. The but is that the valid application criteria in the Schedule 1 provision says that certain people can't lodge a partner visa onshore. We're going, hold on, it's just a minute. Regulation 2.12 says I can. Yes, all that Regulation 2.12 says is you may be able to apply. It doesn't say you will be able to get it, the visa. It's just saying which type of people may consider making applications. But if you find that there's a bar in Schedule 1 to valid applications, then you can't even lodge the whole thing. So it's important to be aware of what that bar is, and we'll come on to that. 8503, can't lodge onshore unless you get a waiver, and the waiver is hidden away in Reg 2.054. So get that super glue out and glue 8503 with Reg 2.054. Glue those numbers together in your head as well. Because the link is that's the only way of getting away from 8503 as a no further stay, unless you want to apply for protection. The other thing is subclasses 491 and 494, which are the temporary visa, regional visas, they have a requirement in Schedule 1. Schedule 1 is always valid application issues that says you must hold the visa for 3 years before you can even apply. You must hold the 491 or 494 visa for 3 years, for example. Until then, you can't apply for a partner visa. So that's a bar in itself, all right? And it just so happens that 491 and 494 are also listed in Regulation 2.12. So there's many traps. There's Section 46A, unauthorised maritime arrivals. Section 48. Section 48 is not difficult, really. I know a lot of people think, oh my God, it's hard. It's not. Just read it. Are you a non-citizen? Yes. Are you in the migration zone? Yes. Do you hold a substantive visa? No. Since you last entered Australia, have you had a visa refused? Yes. Was it refused because of character? No. Therefore, Section 48 applies. Have you had a visa cancelled? Yes. Was it cancelled under one of those sections? Yes. Therefore, Section 48 applies. See how you can read that? That's the and, the and, the and, the and. They all go together. And Reg 2.12 says what we can do otherwise. We've got 3-year bans, 5001 deportation, which doesn't happen. 5002 is removal. Okay. Are these provisions, sometimes people ask about the 3-year ban provisions in FIC 4014 and FIC 4013. They don't apply to all visas. They tend to apply to most temporary visas, but not to the temporary partner or the fiance. So that's useful to know. All right. I said Section 48 had a trap. The trap for the partner visas is in Schedule 1. Schedule 1 is valid application. And it's useful that it's Schedule 1 because you've got to start somewhere to get the application validly lodged to get into the visa house. You've opened the visa door. If you can't open that door, you don't get into the visa house. And Schedule 1 is all about validly getting in, validly lodging the application. So it talks about certain categories of visas a person's had refused, and you see they're all partner visas, and some of these don't exist anymore, but they're old type of partner visas, but mustn't have been refused any of the following since last entering Australia, all the partner visas. So I have a client, for example, who is in, client was in a relationship with person number 1. Client and person number 1 broke up. Client, as case is refused, goes to the tribunal. Client's in the tribunal, meets person number 2. Client and person number 2 fall madly in love and start living together. So there's a de facto possibility that needs to be worked out there. Tribunal says, no, sorry, bad luck, case is refused. You don't meet the criteria. Your sponsor is no longer sponsoring you anymore, and you don't meet the exceptions, which we'll look at next week. Then we go, okay, well, what do we do? Oh, I know, Section 48 says, because I've had a visa refused, my first partner visa was refused. Section 48 says I can lodge another visa. Section 2, Reg 2.12. Remember, it's glued to my head. Section 48, Reg 2.12. And I look in Reg 2.12 and he goes, oh, look, there's partner visa. Yes, I'll lodge a partner visa. Then I dive into the partner visa and have a look in the permanent, the 801. This doesn't appear in the temporary. It only appears in the permanent Schedule 1. It says, oh, by the way, have you had a partner visa recently refused while you're still on shore? Bad luck. You can't lodge another partner visa on shore. So that's why you can't lodge the partner visa. Not because it's not in Reg 2.12. It's because the valid application requirement of Schedule 1 prevents it. And there's no exception. You can't go, oh, this is unfair. Like, who cares? Immigration don't care whether something's fair or unfair. They're not interested in fairness. They're interested in what the regulations say. The minute you start running an argument that it's unfair, you've lost the argument. Forget the unfairness. Focus on the regulations. Okay, is there a way of getting around this problem with partner visas? There isn't in the partner area because you'd have to leave Australia and lodge offshore. There may be an alternative in terms of ministerial intervention, which we're not covering in this part of the course. We did that in 506. But that may be the way of resolving this problem, is to use a ministerial intervention power. But in terms of lodging a partner, you can't. Okay. So let's assume my scenario is that my first visa application that was refused wasn't a partner. Let's say it was a student visa. And I'm on shore with my visitor. I've lodged a student visa. It's been refused. I'm now in a relationship and I want to lodge a partner. Can I do that? Okay. Where do I start? Section 48. Am I holding a substantive visa? No. Have I had a visa refused or cancelled since last entering Australia? Yes. Am I in Australia? Yes. Okay, so it seems that I'm affected by Section 48. Now, where do I go? What's glued in my head? Reg 2.12. I go off to Reg 2.12. Is partner visa in there? Oh, yes, it is. Partner visa. Okay. And then I go, I remember something that Kerry Murphy said something about there's a problem with partner visas and Schedule 1 or something. So let's have a look in Schedule 1, and it says that if you've had a partner refused, you can't lodge another partner on shore, but that doesn't prevent you lodging a partner. If you haven't had a partner refused, if you've had, say, a student or something else refused, that's okay. You can lodge something else on shore. But remember, there's always a but. The but is that you must at the same time lodge certain things. So there must be a Australian citizen, the sponsorship must be done. So that's the sponsorship application. Now, crazily, when you're lodging these on, you can only do them online. You can't actually complete a draft sponsorship form until you've completed and lodged the partner form. So you've got to do them the other way. But once you've lodged the partner, and you get that beautiful little email, you've lodged the partner, then you can go ahead and finish and lodge the sponsorship form for the sponsor. So that's possible to do. So you have to have enough time sitting around. Don't think, oh, I've got 5 minutes, I'll get this off and running. and I'll lodge the part of the sponsorship tomorrow. No, it's got to be done basically the same day. The second thing is a requirement of 2 statutory declarations. So you've got to look at, well, what is a statutory declaration? That's a Commonwealth statutory declaration, not a state one. And they have a particular format. Statutory Declarations Act sets it out. And you must have at least this much in them. It must at least say the person is an Australian citizen, permanent resident, or eligible New Zealander, who's not the partner sponsoring them, might be their best friend, might be their mother, father, brother, sister. And they go, hey, I know Fred. Fred is my best friend since we were at school together. And I know he's now in a relationship with Mary, and they've been together for nearly 2 years. And I think they're in a de facto relationship, genuine relationship. And this is some other things I know about them. So you might put all that in, but at least identifying your person, that criteria, and that you believe they're in a genuine relationship, either de facto or married. And it can't be more than 6 months old. Now, people are 6 weeks old. If people are talking about a 888 form, maybe. Check if the 888 form is a statutory declaration. Check that, because there was a time when it wasn't. The requirement is it says a statutory declaration. It doesn't say a 888 form. So check that the 888 form actually is a statutory declaration, because I'm not sure that it always is. Just check that.
It's no longer a statutory declaration.
It isn't anymore.
No, it's just a statement by witnesses.
A witness statement.
So yeah, you cannot use a Form 888 to meet the valid application criteria. You can use it for decision criteria in Schedule 2. So if you just have a regular old partner visa where you need a couple of witnesses to say that, yes, they know you and this is how long they've known you, use the Form 888s. But if you're trying to meet these validity criteria because someone is affected by Section 48, you need a Commonwealth statutory declaration.
Thank you very much, Michelle. Very nicely put. So what we have here is validity issues. Validity. Remember, you're not even in the house at all until you've got through the validity door. Okay? You haven't even got an application for immigration to look at, and literally they're not going to look at it. They just go, no, not valid application, not interested. So these are extra validity requirements. Okay? So this is really important to keep in mind. So there's multiple validity requirements hidden away in the Schedule 1 provisions of the permanent visa. Now, when you lodge the partner visa online, you're lodging a temporary and a permanent at the same time. They're 2 separate subclasses, 2 separate visas, but the process is done at the same time. So just be really careful about all these factors, because if you don't do it correctly, it's sent back. Literally, it's sent back. And you don't get it. Okay, so there's other requirements here in terms of the these regional visas. Sponsorship 120J, remember that's the person you can't sponsor more than 5 in a lifetime, and they have to be 5 years apart, unless there are exceptions, compelling circumstances. 120KB, that's the sponsorship, other sponsorship limitations. 120KC, limitation and waiver. Schedule 3. Let's spend a little bit of time on Schedule 3.